First, U.S. financial institutions possessing or controlling funds in which a designated FTO or its agent has an interest are required to block all financial transactions involving these funds. Second, representatives and specified members of a designated FTO are inadmissible to this country. And third, as relevant here, it is illegal for anyone within the United States or anyone subject to its jurisdiction to provide material support to a designated FTO. Based on this third effect, a number of lawsuits arise where individuals and groups seek to challenge the constitutionality of this scheme. And there really are two major classes of constitutional arguments. The first derives from a Supreme Court case with which some of you may be familiar called Scales versus United States. Scales is a 1961 decision that basically stands for the proposition that the Constitution prohibits guilt by association, right? That a criminal offense that merely imposes guilt because of your association with another is unconstitutional under the First and Fifth Amendments. But second, there are all of these terms in the material support statute, the meaning of which is not immediately clear. And so separate from the freedom of association issue is the more complicated and more specific question of what we call vagueness doctrine in constitutional law, whether these terms are so unclear that a reasonable person cannot know where the line is between conduct that is legal and conduct that is prescribed. And so these challenges arise immediately after the Anti-Terrorism and Effective Death Penalty Act enters into law in early 1997. The plaintiffs in this case, about whom you will hear much more from Shane, are 6 organizations, a retired federal administrative law judge, and a surgeon. And the two groups at issue are the Kurdistan Workers' Party, or the PKK, and the Tamil Tigers. These are entities that engage in a wide variety of, I think it's safe to say, both lawful and unlawful activities. To that end, both were designated by the Secretary of State in 1997 as FTOs. And so the plaintiffs subsequently sued, challenging the constitutionality of the statute and arguing only that they seek to provide support to nonviolent and lawful activities of the PKK and the Tamil Tigers. In the first round of litigation in 1998, the district court ruled in part for the plaintiffs and enjoined the Attorney General's enforcement of AEDPA with respect to its prohibition on providing training and personnel to PKK and the Tamil Tigers on the ground that these prohibitions were unconstitutionally vague because they could be read to criminalize conduct protected by the First Amendment. Specifically, the court noted, a plaintiff who wishes to instruct members of a designated group on how to petition the UN to give aid to their group could plausibly decide that such protected expression falls within the scope of the terms personnel and training. But the court otherwise rejected the plaintiff's claims, and the Ninth Circuit affirmed, albeit by adding a mens rea requirement to the statute, i.e. that the government must prove that the defendant knew that the organization to which it provided material support was an FTO or was otherwise engaged in unlawful activities. At the time, the Supreme Court denied both the Humanitarian Law Project's petition for certiorari and the government's conditional cross petition for certiorari, sending the case back to the lower courts. After 9/11, Congress enacted the USA Patriot Act, one provision of which amended the material support statute to include a prohibition against providing, quote, expert advice or assistance, unquote, to a designated FTO. The plaintiffs filed a separate action challenging this provision on constitutional grounds and again prevailed in the district court, which ruled that this provision, too, was unconstitutionally vague. At least largely in response to this exact litigation, Congress, as part of the Intelligence Reform and Terrorism Prevention Act of 2004, or IRTPA in acronym land, amended AEDPA, the 1996 statute, in an attempt to alleviate some of the constitutional concerns that had arisen. Thus, the IRTPA codified the Ninth Circuit's mens rea requirement, specifying that the prohibited material support must be knowingly provided. Congress in the IRTPA also amended the definition of material support in 3 other ways. First, it included an additional ban on providing, quote, service, unquote. Second, it defined for the first time the terms training and expert advice or assistance. And third, it clarified, or at least attempted to clarify, that the prohibition against providing personnel to designated organizations was somewhat limited, and tried to incorporate the Ninth Circuit's analysis of that issue. To sort of crystallize this, under IRTPA, training refers to, quote, instruction or teaching designed to impart a specific skill as opposed to general knowledge, unquote. Expert advice or assistance encompasses, quote, advice or assistance derived from scientific, technical, or other specialized knowledge, unquote. And personnel includes, quote, one or more individuals who work under the terrorist organization's direction or control, or who organize, manage, supervise, or otherwise direct the operation of that organization, unquote. So this is what the IRTPA tries to clarify in 2004. Okay, getting to the current lawsuit. After and in light of the IRTPA, the case was sent back to the district court, which ruled that the specific intent requirement vitiated the plaintiff's guilt by association claim. As to vagueness, the district court held that the IRTPA did not cure the constitutional problems with regard to the material support statute's prohibition of providing training or service, but that it did cure the constitutional problem with regard to the prohibition on providing personnel. With regard to the ban on providing, quote, expert advice or assistance, unquote, the court upheld the portion of that definition that referred to scientific and technical knowledge, but struck down the ban on providing other specialized knowledge as, again, being unconstitutionally vague. And the Ninth Circuit affirmed the district court in every respect. Based on the Ninth Circuit's decision, the government petitioned for certiorari challenging each of the three holdings that had found individual aspects of the material support statute to be unconstitutionally vague. The Humanitarian Law Project opposed certiorari, but filed a conditional cross-petition, noting that if the court took the case, it should also consider whether the lower courts were wrong in upholding the bans on providing scientific and technical knowledge and personnel to designated FTOs. And the Supreme Court granted both petitions last September. Hence, the question presented in this case, whether 18 U.S.C. 2339b, parentheses A, parentheses 1, which prohibits the knowing provision of any service, training, expert advice, or assistance, or personnel to a designated FTO violates the First and Fifth Amendments. To be clear, this case is not about charitable donations, despite a number of reports to the contrary. That issue has been settled by case law, and it is not fairly within the ambit of the question presented. This case is entirely about these other types of material support that are non-monetary, that go to assistance, to counseling, to other conduct where I think we could have a spirited debate about whether it is protected conduct under the First Amendment or conduct that may lawfully be criminalized. And so with that, I'll sort of shut up and let Shane explain more about the details of this case in particular. Thank you.
Well, thanks, Steve, for handling the hardest part of this, I suppose, which is making sense of the history of a case that's gone on for 12 years.
That made sense?
It did, yeah. I'll start by talking a little bit about what our clients want to do. Humanitarian Law Project and Judge Vladeck sort of specialize in nonviolent conflict resolution. They've stated that they wish to sort of, talk to the PKK and its membership about methods for peacefully resolving its disputes with the Turkish government, carrying out human rights monitoring in Kurdish parts of Turkey, and bringing human rights complaints to various international bodies. The Tamil groups have a lot of sort of, I suppose, non-speech aid that they initially proposed to do. So just to give you background, the LTTE, the Liberation Tigers of Tamil Eelam, for the longest time during the course of this litigation, were basically the functioning government in the eastern sort of parts of Sri Lanka, the parts that were basically ethnically and linguistically Tamil speaking. And these were areas that were heavily affected by the Civil War, as you can imagine, but also devastated by the Boxing Day tsunami in 2004. And so as the functioning government, it was very difficult to do just sort of material humanitarian aid in those areas without dealing with the LTT in one way or the other. So our Tamil plaintiffs groups, a lot of which were consisted of Tamil Sri Lankan American physicians in the U.S., wanted to do medical aid in those areas. They wanted to send money and medicines and those kind of things to help in both infrastructure reconstruction in the Civil War devastated area, but also